the distinguished justices in absentia, the National Data Protection Authority Director, the Deputy Vice Chancellor, who is also our host, representatives from PILAC and the Makerere School of Law, the Mooters, students, and distinguished guests. You're most welcome to be part of this day as history is being made.
Themselves. And the point I'm trying to make is
why can be held accountable for issues.
Sure, that a non-disclosure agreement is signed. Now
The theme for the privacy moot competition today, which is balancing privacy rights and national security, navigating the impact of surveillance laws on individual freedoms, is thought-provoking and critical for the proper implementation of the Data Protection and Privacy Act of 2019.
The respondents relied on the 2010 decision of Uzun versus the Republic of Germany.
It was the position of the law, it was lawful that we did so, and it could be justifiable in a democratic society.
the GPS trackers in that much vehicles, rationally speaking, I withdraw that word.
My question is, are all the 1.5 million vehicles belonging to people suspected of terrorism?
When the government is interfering into privacy, it must be lawful, it must be pursue a legitimate aim, and it must be necessary.
Unwanted witness is commonly known for the right to privacy and data protection, but we do a whole host of so many things. Internet governance, digital inclusion, freedom of expression, but also the Moot is just one of those components that we focus on when it comes to the right to privacy.
I want to thank Unwanted Witness for continuing with these privacy moot competitions. They are a good step in the right direction towards building capacity in understanding what privacy is, awareness on matters of privacy, how we can enforce our right to privacy, and also build capacity for the future privacy defenders and practitioners.
Ladies and gentlemen, Code 15 and Code 02, proceed to the finals. Thank you so much.
My lords, we pray that this honorable court grants and declares that the respondent, the acts of the respondent state were not in violation of the right to privacy, and the limitations taken by the respondent state are justified under the principle or the circumstances of national security, prevention of crime, and public safety.
Regulation 12(1) of the data protection and privacy regulation states that where the collection and processing of personal data possesses a high risk to the rights and freedoms of natural persons, the data collector, data processor, and data converter shall, prior to the collection, processing, and carrying out an assessment of the invested collection, shall ensure that they do an assessment.
Chronology is important. The way you present your case. Present it in a way that you're starting from a good introduction, going into the meat of your arguments, and then conclusion is very important. And I'm happy, I like the way it was concluded.
Always identify what the test is. And I think the Deputy Attorney General was trying to do that. But you can be more precise around it.
Citation and use of authorities was fabulous for both teams, and I really want to thank you for that.
I hope that this moot has not only enhanced your knowledge in the area, but that it will trigger debate and information to guide policy makers, especially those from the government of Uganda.
We'll start with the best written submission applicant.
And the winner is Islamic University in Uganda.
Please appreciate them as they come.
Best Oralist Privacy Moot Competition 2023 goes to Martin Tije.
The first runners-up for the Privacy Moot Court Competition 2023 are Cavendish University.
Already evident. The overall champion for the Privacy
Und
Moot
ich mit all den
Competition
Sportlerinnen
2023
mit der dicken, fetten
Islamic
Zugabe
University.
von 9,6